Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today is the channel's 5th birthday. It is true. Today is the channel's 5th birthday. It was on this day, 5 years ago, that I, your friend, Uncivil Law, then known as Internet Law Review, decided to start the channel. Now, the channel was technically created, of course, then, but when the channel really got going is somewhat more open to discussion and debate, because the channel's existence, well, for a while, it wasn't really doing anything, and it was mostly just kind of existing in a collab with Leonard French for a lot of time. This is a multi-year journey. I guess the channel really, in some senses, go back 6 years, if not more than that, because it was about 6 years ago, give or take, that I first approached Leonard French of Lawful Masses and said, "Hey, Leonard French of Lawful Masses, I'm also a lawyer. Would you like to maybe do a collab sometime?" Now, at the time, I had no channel at all, but he said yes, and he let me onto his channel, and we engaged in many collabs together. And then at some point, I was like, maybe I'll form a channel, and maybe I'll make some content too. And then for a while, didn't really do much of that either. And then started making content on the regular. So it's been a multiple year journey, but 5 years ago, the channel at least was created, so we can celebrate that together. So hats off to the man with the hats himself, Leonard French, who helped this channel get started. And today we celebrate our channel's 5th birthday, and it's awesome. And we're going to celebrate this channel's 5th birthday with many different great birthday presents. Not the least of which, incidentally, is through a shipping delay, I'm getting my play button today. It was supposed to arrive yesterday, but it didn't arrive yesterday. But it's going to arrive today. It's on the truck and everything, they swear. So it's going to come today. So hey, what a nice gift for the channel for its 5th birthday, that 100,000 subscription plaque. That's pretty badass. But we're also going to celebrate by doing something I love, which is really, really hardcore geek law. So let's do some really, really hardcore geek law. This is the case of West Virginia versus EPA. Also the cases of North American Coal Corporation versus EPA, and Westmore Mining versus EPA, and also North Dakota versus EPA. This is 4 cases rolled up into one. So what we're trying to determine through this is trying to determine what the EPA can do. What is its authority? What regulations can it have on the clean air and stuff? What authority did Congress give it? Did it exceed that authority? Was Congress's authority grant clear? And so forth and so on, right? So we are going to try to read this, and we're going to try to decide whether or not the Supreme Court was faithful to the principles of originalism, because there has been some criticism, including from the dissent, that maybe not. So we're going to analyze this not only for the law, but also for whether or not it is true to the fundamental principles of originalism that the majority opinion would seek to uphold. So let's do all that. Chief Justice Roberts delivers the opinion of the court for a 6-member majority. The Clean Air Act authorizes the EPA to regulate power plants by setting standards of performance for their emission of certain pollutants in the air. That standard may be different for new and existing plants, but in each case must reflect the best system of emission reduction the agency has determined to adequately be demonstrated for the category. For existing plants, the states then implement that requirement by issuing rules restricting emissions from sources within their borders. So far, so good. Since the passage of the Act 50 years ago, the EPA has exercised its authority by setting performance standards based on measures that would reduce pollution by causing plants to operate more cleanly. In 2015, however, the EPA issued a new rule, concluding the best system of emission reduction for existing coal-fired power plants that include the requirement that such facilities reduce their own power production of electricity or subsidize increased generation by natural gas, wind, or solar sources. Okay, so the best system of emission reduction for coal power, according to the EPA, is the reduction of production of electricity or by increased generation of other sources. So right away, if this is the proper framing, I see the problem, right? We can do things to make the coal power plants cleaner unto themselves. Seems to be the thrust of the statute. So if we want to make them install certain filters or scrubbers or whatever that would make the coal power cleaner, we can do that. What we want to do is simply reduce the amount of electricity they produce, which I suppose is one way of making it cleaner, because we're not producing as much electricity, so we're not burning as much coal, therefore the emissions go down. But we're not really changing the nature of the emissions, we're just changing the nature of the production, which is slightly different. Or, in the alternative, by offsetting to generation of other things. So I see the problem immediately. This may not be the best system of emissions reduction. Turning off the fires is not a way to reduce emissions. It's something different than that. All right, let's read on. The question before us is whether the broad conception of EPA's authority is within the power granted by the Clean Air Act. Always a good place to start. Does the statute authorize the EPA to do this? The Clean Air Act establishes 3 main regulatory programs to control air pollutant from stationary sources such as power plants. One program is the New Source Performance Standards program of Section 111 at issue here. The other 2 are National Ambient Air Control Standards set out in blah, and Hazardous Air Pollution set out in blah. Unsurprisingly, there might be multiple different authorities for the EPA, and they might have multiple different regulations. That isn't necessarily inappropriate, by the way, of course, because we might want to regulate different kinds of power differently. So the statutes may very well allow for that, either explicitly or implicitly. And the EPA might very well want to regulate different kinds of power differently for very legitimate reasons, right? Treating different things differently is logical. The question of what makes something different, of course, is a whole other set of problems, but at least in principle makes sense. The programs address air pollutants that may reasonably be anticipated to endanger the public health or welfare, and the presence of which in the ambient air results from numerous or diverse mobile or stationary sources. So it comes from multiple different places. Okay. After identifying such pollutants, the EPA establishes quality standards. The quality standards represents the maximum airborne concentrate of pollutant the public health can tolerate. This seems very logical, right? We don't want pollutants in the air. The EPA, we want you to identify the pollutants, then we want you to identify the maximum amount of pollutants that are there, and we want you to put in place regulations that will drive pollution sources below those limits. This seems quite reasonable, at least in sort of its gross conception. The EPA does not choose which sources must reduce their pollution and how much to reduce that ambient target. Okay, so the EPA does not choose particular sources. Okay, instead, Section 110 of the Act leaves that task in the first instance to states, requiring it to submit a plan to implement and maintain such standards. Fair enough. All right, so the EPA is a big national agency. And as a big national agency may not be particularly well aware or even equipped, or may not necessarily be desirable for them to be the ones that are going to set it for each individual state, right? The EPA simply says, okay, we've determined that more than this amount is bad. We don't try to attempt to regulate individual sources. What we're simply going to say is this amount is bad. Thank you, Scott, for the gift of memberships. It's very, very kind of you. We're simply going to say what amount is bad. And it's up to you states to pass regulations within your states that will meet those targets. We're going to give it to you in the first instance to do this so we don't have to. Give more control to the states. This seems promising. All right, let's continue on. The second major program governing stationary sources is something else. That program primarily targets pollutants, other than those already covered by the other program, that present a threat of adverse human health effects, including substances known or anticipated to be carcinogenic, mutagenic, teratogenic, neurotoxic, or otherwise acutely or chronically toxic. Okay, so we have a second source of things. We have pollutants that are bad, and then we have pollutants that are really bad. This makes logical sense. Not all pollutants are created equal. We might want to discriminate, that is, to make different programs for different kinds of pollutants because different ones are different bad. And we might have to have different kinds of measures for different levels of bad. This makes logical sense. Carrying on. The EPA's regulatory role with respect to these pollutants is different in kind from the other program. Okay, there the EPA is generally limited to determining the maximum safe amount of covered pollutants in the air. As to each hazardous pollutant, by contrast, the agency must promulgate emission standards for both new and existing sources. Makes sense. If it's really, really bad, then we don't really care that much if it's coming from a new or existing sources. I mean, we could care, right? We could grandfather those things in, but we're not going to. That also makes logical sense. Those standards must require the maximum degree of reduction in emissions that the EPA, taking into consideration the cost of achieving the reduction and any non-air quality, health, and environmental impacts and energy requirements, determines is achievable through application, measures, process, methods, systems, or techniques of emissions reductions. This sounds initially like a really broad language, which might be appropriate. It might be appropriate. Congress can give broad authority. The limits of that broad authority is probably where we're going to wind up getting. It's like, how broad really is this authority? But the idea, at least in principle, that we want to give the EPA really broad authority to reduce the really, really bad chemicals to the maximum degree possible by taking into consideration a whole bunch of factors, then that makes sense. We would very much like to reduce the carcinogenic chemicals in the air, please. Please do that to the maximum extent technologically feasible, basically, is what that says in so many words. Makes logical sense. In other words, the EPA must directly require all covered sources to reduce their emissions to a certain level. And if it chooses that level by determining the maximum degree of reduction it considers achievable in practice by using best existing technologies. That's what they're mandated to do. So they are mandated to drive this to the maximum degree possible, because we've apparently determined these chemicals are really, really dangerous, and we'd like as few of them to exist as possible. So, unsurprisingly, the EPA therefore is tasked with driving these chemicals to the minimum level possible as might be technologically feasible. Okay, fine. Thus, in the parlance of environmental law, it directs the agency to impose technological-based standards for hazardous emissions. Yeah, that makes sense. This sort of technological-based approach focuses on control techniques that are available to industry entities and requires the agency to ensure that regulated firms adopt the appropriate cleanup technology. This all seems very logical. The third air pollution control scheme is something else. That section directs the EPA to list categories of stationary sources it determines cause or contribute significantly to air pollution which may reasonably be anticipated to endanger the public health or welfare. Under that relevant law, the agency then must promulgate for each category federal standards of performance for a new source. A standard of performance is one that reflects the degree of emissions limitations achievable through applications of best systems of emission reduction when taking into account the cost of achieving the reduction and any non-quality health air impact. This sounds very similar, by the way, to my mind. Thus, the statute directs the EPA to determine, taking into account various factors, the best systems of emission reduction which has been adequately demonstrated, ascertain the degree of emission limitations achievable through application of systems, and impose emission limits on stationary sources that reflect that amount. Generally speaking, a source that may achieve that emissions cap in any way it chooses. The key is pollution may be no more than the amount achievable through application of best systems of emission reduction adequately demonstrated. The EPA understands this analysis on a pollutant-by-pollutant basis, which, of course, is logical, right? What is the best technology for each individual pollutant? I mean, different pollutants will be able to be sifted out of the pollution stream to different degrees, right? I mean, the technology is not going to be equally good at reducing every pollutant equally. We're not trying to achieve that. Well, we are trying to achieve that. We're just trying not to demand that at the moment. We are only trying to demand that for each particulate that we're regulating, that you drive each of them to the minimum amount possible that's technologically feasible. That may, in practice, reduce some pollutants more than others, but it's what the technology allows for. So we are going to impose on you these limits. This makes total logical sense, by the way. And also makes total logical sense that Congress has this power. First of all, Interstate Commerce Authority, but if you don't like that, it's also because these are pollutants that necessarily, by their application, transverse state lines. and transfers from one state to another. And therefore, it forms a trespass. This, incidentally, is the same as it is in property law for individuals, or at least in principle it is, right? If I own a piece of property and you own a piece of property, trespass is when things trespass onto your land. If I own, for example, a smelter or something, I don't know, and those pollutants wind up on your land and detract the value of your land, well, that's a problem, because the things from my land are impacting the things from your land, right? My rights stop at your boundary lines. This is not like incredibly hard as a principle. So like my ability to do whatever I want on my land stops where your land begins. So if things from my land are coming onto your land, that's a problem. If those things are the pollutants I'm generating, that's a problem. If those things are the pollutants that are generating from within my state and now are trespassing into your state, I'm not respecting your state's boundaries. So the federal government obviously has some interest here in regulating that for that reason. So it makes total logical sense, right? What I do on my land can't affect you on your land. This is pretty basic stuff in some ways. Okay, great. And so we want to create this thing called the EPA, which is going to facilitate that says, hey, pollution sources, we can't help noticing that you're polluting. The Congress has said that we are mandated to impose upon you technology that will reduce these pollutions to the maximum extent technologically feasible, to reduce this problem down as far as we can. This seems like a logical solution to the problem. Great, moving on. Although the thrust of the statute authorizes regulations from existing sources. Great. New, modified, existing, fine. We could treat these things differently. We don't have to, but we could. But under the relevant section, we're not going to. Once the EPA has set a new source standard for addressing emissions of a particulate pollutant, it must then address emissions of that same pollutant by existing sources, but only if not already regulated under some other program. Great. So once we identify it for a new source, we want to make sure that all the other sources are also not polluting. This seems logical. Existing power plants, for example, emit many pollutants covered by relevant standards. The section thus operates as a gap filler, empowering the EPA to regulate harmful emissions not already controlled. Fantastic. So we have a multiple different statutory scheme. We have multiple different statutory programs, each of which are created by Congress. And Congress says, hey, as to these kinds of pollutants, we want you to regulate it this way. As to these kind of pollutants, we want you to regulate this way. As to these kind of pollutants, we want you to regulate this way. And then we discriminate from there, not only within the nature of the pollutants, but also the nature of the sources. New sources, modified sources, existing sources, so forth and so on. And then we have this gap filling provision of statute, which basically says, okay, look, if you identify some sort of new stuff for new plants and it's not already regulated, then you can regulate it, because that would be dumb if we didn't let you. If you're already regulating it under those programs, then continue to regulate it under those programs, because that's what those programs are for, those things. If you are doing something new and those programs don't cover it, then fine, this program covers it. This all sounds fine. Congress apparently is creating a somewhat segregated discriminatory framework, but that's perfectly fine when it comes to things. And we say, okay, well, these pollutants this way, these other pollutants this other way, as to these sources this rule, as to these sources this rule. This is something Congress can do. And to the extent that someone is going to do it, it is preferable that Congress do it, because Congress is the political branch. Congress is the one that's accountable to the people. We would prefer Congress be the one that's creating these boundaries rather than the agencies, right? And this is where my skepticism of the administrative state comes in. It's like, well, my skepticism of the administrative state is one thing, but if Congress wants to do it directly themselves, Fine. Then we're well past any sort of administrative state concerns, and now our only concerns, which are many, is, did Congress do it clearly enough? Do they have the power to do this? Are they infringing on concepts of federalism and other concepts? But the fact that Congress is the one doing it, well, at least in the first instance, that's the appropriate body. So far, so good. We're doing great. Although the states actually set the rules governing the plants, the EPA itself still retains primary regulatory function. Perfectly logical. The agency, not the states, decide the amount of pollutant reduction that must be ultimately achieved. Perfectly logical. This is something that obviously is a national interest. The pollutants are crossing state lines. This is something that's a national interest. We want, as a national government, to regulate the pollutants. Cool. It does so by determining as whether the new source rule is the best system of emission reduction that's been adequately demonstrated. Please do this to the maximum extent technologically possible. Fine. The states then submit plans containing the reductions that they intend to adopt and enforce in order not to exceed those programs. Fine. Fantastic. We want the states to be able to do this. We could do it, of course, ourselves directly, the federal government, and we can't force the states to cooperate. And if they don't want to cooperate, then the EPA will do it themselves. But we are empowering the states to have more nuanced plans for the particular problems that are within their particular state. So that's honoring federalism, not thwarting it, right? If we say to the states, hey, would you like the ability to regulate this more specifically, rather than us do it with a big-ass hammer? It's like, well, we're going to do it regardless of whether you want us to or not, because it's a national interest. But we're going to give you, states, the power, if you like, to regulate this in the first instance, so that you can create regulations that more appropriately reflect your state level concerns in accordance with the targets we're going to set, because we should and can, because they're national targets. This all sounds perfectly fine. And to the extent the states say, yes, we would like the ability to, do that, because it allows us to have more control over the specifics, rather than have the EPA, the big federal agency, just impose it from on high. This is preferable to us, so we'll do that. So far, so good. Great. So far, so good. Reflecting the ancillary nature of the section, the EPA has used it only a handful of times since the enactment of the statute. Okay. For instance, the agency has established emission limits on acid mist from sulfuric acid production, sulfide gas released by kraft pulp mills, and emissions of various harmful gases from municipal landfills. It was only a slight overstatement from one of the architects of the amendments of the Clean Air Act to refer to Section 111 as an obscure, never-used section of law. This is fine. This is fine. We are trying to create an entire regulatory scheme by Congress, which is where we're supposed to be doing this, and we have multiple different authorities. And in these specific authorities, we have said specific things. But then we have this gap filler provision, because Congress, recognizing it can't think of everything, said, okay, look, we've created a gap filler provision. And then, of course, the problem is that the agencies use the gap fillers to try to drive everything through, right? Even where they're not supposed to. So this is where the thing becomes a problem. This is basically the and other stuff problem. We see this a lot of different ways. We see it in the text of statutes. We see it between statutes. We see it now in the context of a multiple statute scheme where we have an and other stuff statute, right? Congress is recognizing it hasn't thought of everything. So it's creating the and other stuff provision. And then the agency is looking and say, ooh, other stuff. Let's drive all the things through the and other stuff provision. And that's then when the courts have to go, no. No, that's not what that's for. I understand you want to use it to mean everything, but that's not what that's for. So this setup is not surprising. It might or might not be surprising in the particulars, but the ideas that we're talking about make total logical sense, at least. So in sort of the grand conception of it all, everything makes sense. Congress has delegated to the EPA the power to regulate pollutants because they transfer state lines and national lines. Great, national interest, fine. And they say we want the maximum extent technologically possible. Great. And we create multiple different statute schemas. And one of the schemas basically says the and other stuff provision. And EPA wants to ram everything through the and other stuff provision. This is a perfectly sort of normal, typical setup for these things. So the complexities in the specifics, though, are not surprising, but the general principles make sense. All right, so things changed in October 2015 when the EPA promulgated 2 rules addressing carbon dioxide pollution from power plants, one under Section 111B, one for new plants and one for existing plants, because there are different rules, or at least there can be. Fine. Both were premised on the agency's earlier finding that carbon dioxide is an air pollutant that may reasonably be anticipated to endanger the public health or welfare by causing climate change. Carbon dioxide is not subject to the quality standards law and has not been listed as a toxic pollutant. So it's not under that statute. It's not under the NAAQS thing. So we have to look for it somewhere else. Fine. The first rule announced by the EPA established federal carbon emission limits for new power plants of 2 varieties. Fossil fueled fired emissions from electric steam generating unit, which are coal-fired, and natural gas, stationary combustion turbines. Following the statutory process set out above, the agency determined the best standards, what is technologically possible, for the 2 categories. For the steam generating units, for instance, the EPA determined the best technological means was a combination of high efficiency production process and carbon capture technology. EPA then set emissions limit based on the amount of carbon dioxide the plant would emit under these technologies in place. Okay, the second rule was triggered by the first. Because the EPA was now regulating carbon dioxide from new coal and gas plants, Section 111D required it to also address it from existing. It did so through what it called the Clean Power Plant Rule. In that rule, the EPA established final emission guidelines for states to follow in developing plans to regulate existing power plants within their borders. To arrive at these guideline limits, EPA did the same thing it does when imposing regulations on new sources. It identifies the best technological means. Okay. The best technological means the agency selected for existing coal-fired power plants, however, was quite different from the ones it chose for new sources. All right. So far, this sounds logical, right? We want to regulate carbon dioxide. Now, let's assume that we have the power to do that, which is a big assumption. But let's assume we have the power to do that. And we want to do that through technological means. Fine. So one of the things we could do, for example, is carbon capture. If we can capture the carbon dioxide, that would be a technological means of reducing the amount of pollution. This makes logical sense. Right. Now, we still have to get into issues about it being within the scope of technological reality. Just because something can be done doesn't mean it's really technologically possible, because you have to factor cost into this by the text of the statute, incidentally. So whether or not it, is economically efficient or, whatever, but like in principle, it makes sense. We want to regulate the amount of carbon dioxide out of new plants. We're going to do that through carbon capture. That is a technological mean. So then we have to maybe go to other parts of the analysis. This is one of the things in law that you have to remember. Just because you satisfy one part of the analysis doesn't mean you satisfy all parts of the analysis. So okay, this is a technological mean. This seems like that's okay. So then we move into other parts and see whether we have a problem somewhere else, because you have to satisfy all the elements of the law. But makes sense. As to the new plants, but as to existing plants, we're going to do something different, which we can do potentially, but they have to be technological in their nature, it seems. The best technology that's in existence for the existing plants includes 3 types of measures, which the agency called building blocks. The first building block was heat rate improvement at coal-fired power plants, essentially practices such plants could undertake to burn coal more efficiently. More efficient processing of stuff sounds like a good thing. But such improvements, the EPA stated, would lead to only small emission reductions because they're already operating near optimum efficiency. So we can do better, but not much better in terms of the amount of energy we can squeeze out of this thing, or we're near the limits of what technology will allow for. On the agency's view, much larger emissions reductions were needed from them to address climate change. All right. So the agency included 2 additional building blocks within its best technological means, both of which involved to include generating shifting from higher to lower emission producers of electricity. See, this seems like this is wrong. This is where we're running into a problem. Right. We're not telling you coal power plants to capture your carbon. We're not telling you to put in place scrubbers. We're not telling you to burn the things more efficiently or apply a chemical or whatever that would reduce carbon emissions, right? We're not telling you to do something that would, while you're generating it, do less of it. We're now telling you to shift power generation from one source to another. That is not a technological method with respect to generation, with respect to the coal-fired power plants. That's just use something else, which is not what the statute appears to contemplate. Because natural gas power plants typically produce half as much carbon dioxide per unit as coal-fired, the agency explained this generation shift would reduce CO2. It very well might, but you are not trying to make the coal plants better. You're trying to make them less, which is not the same thing. Building block 3 worked the same way, except the shift was both from coal and gas-fired to new, low or zero carbon generating capacity, mainly wind and solar. Most of these controls came in application in building blocks 2 or 3. Yeah, I see the problem already. This seems like not in keeping with the schemes that we were talking about, the schemes created by Congress. The agency identified 3 ways in which the regulation could implement a shift to generation to cleaner sources. First, an operator could simply reduce the regulated plant's own production of electricity. Turn down the fires is not exactly a technological means. That's just do less, which is not, no. Second, it could install a new natural gas plant, wind or solar installation, or invest in someone else's existing facility, increase generation there. No. Finally, operators could purchase emission allowances or credits as part of cap and trade. No. No, that's not a technological means. That's a business aspect. Like buy credits is not technological. It's financial. It's different. Under such a scheme, sources can achieve a reduction in emissions, can sell credit representing the value of their reduction to others, where it will count towards emissions caps. This seems to not be within the scope of this regime, as set up by Congress. EPA explained that it was taking these steps would improve a sector-wide shift in electricity production from coal to natural gas and renewables. It very well might, but EPA needs to have the power to do that. Given the integrated nature of the power grid, adding electricity to the grid from one generator will result in instantaneous reduction in generation from other generators, and reduction in generation from one generator leads to instantaneous increase in generation by others. I suppose in some sense that's true. It just might be outside the EPA's power. So coal plants, whether by reducing their own production, subsidizing an increase in production by cleaner sources or both, would cause a shift. This is probably true, but it's not within the EPA's power because it's not really a technological means. The technological means were make the coal plants burn better, make the coal plants burn less CO2, make less CO2 become emitted. Turn off the coal power plants is not what the statute has in mind. That's not a technological measure. No. Having decided the best system of emission reductions adequately demonstrated, and just to remind everyone, by the way, this is only as to existing plants, because the EPA had instituted technological measures with new plants. For example, the carbon capture, which apparently was not possible or was infeasible for old plants. I can't speak to the degree to which that's true, but that appears to be what's going on. So the EPA says, hey, if you want to build a new coal power plant, guess what? You got to put in some carbon capture mechanisms. That may very well be technologically feasible. It may be technologically feasible for a new plant and not an old plant, which would make sense why we're regulating them differently. But in any case, it's a technological measure. Capture the carbon you're burning and do something with it, whatever that might be. Logical. Have you considered not using a coal power plant is not a technological measure? Yeah. So having decided the best system of adequate reduction was one that would reduce carbon pollution, mostly by moving production to cleaner sources, the EPA set about determining the degree of emissions limitation achievable through the application of the system. Well, the amount of reduction would be theoretically 100%, because turn off the plants would reduce the emissions 100%. So the agency recognized, given the nature of generation shifting, it choose between a wide range of potential stringencies for the best method. Put differently, in generation shifting could require anything from little to a lot. Yeah. The agency settled on what it called a reasonable amount of shift, with it based on modeling how much more electricity both natural gas and renewing sources could supply without causing undue cost increase or reducing overall power supply. Based on these changes, the EPA projected that by 2030, it'd be feasible to have coal provide 27% of national energy generation, down from 38% in 2014. Super duper, but do you have the power is the problem. From these significantly projected reductions in generation, the EPA developed a series of complex equations to determine the emission performance rates that states would be required to implement. These calculations resulted in numerical emission ceilings so strict that no existing coal plant would be able to achieve them without engaging one of the three means of shifting generation above. Indeed, for the emission limits of the clean power plant established for existing power plants was actually stricter than the caps imposed simultaneously for new plants. That part is not as much of an like the fact that the caps are more stringent for existing plants might make sense depending on what's technologically possible, but the fact that we're trying to just turn off the plants is the problem. The point, after all, was to compel the transfer of power generation from existing sources to wind or solar. The EPA doesn't seem to have that power. The White House stated the Clean Power Plan would drive an aggressive transformation in domestic energy industry. The EPA's own modeling concluded that the rule would entail billions of dollars in compliance costs, which would be paid for in the terms of higher energy prices, which, to the extent it's a technological measure, might be very well appropriate because the EPA is allowed to do that. The technological measure might cost more. These costs will be passed to the consumer, but the EPA is mandated to do that when it's a technological cost or technologically possible, taking into consideration the economics, because we're not going to require you to do something that's merely technologically possible that's completely price inefficient. A lot of things are possible, if money is no object, but we're not going to go quite that far, which is logical. But the fact that energy costs by themselves is rising is not surprising nor inappropriate if the EPA has the power, which they don't. Require the retirement of dozens of coal-fired power plants. There's your problem. Retirement is another way of turning them off. I don't think you quite have that power. And eliminate tens of thousands of jobs across various sectors. Again, the elimination of the jobs is not the primary problem. It may very well be the case that the retirement eliminates jobs, but if the EPA has the power, they are mandated to do it because of their mandate. Their mandate is to, make the air clean. If that causes jobs to be lost, that is not necessarily their problem as long as they're using technological means. Turning off the power plants is where we run into the problem. The Energy Information Administration reached similar conclusions, projecting the rule would cause retail prices to remain persistently 10% higher in states and would reduce GDP by at least $1 trillion. That's a lot. Just want to say, we're reducing GDP by $1 trillion. That's a lot. That's a lot of impact, man. These projections were never tested because the Clean Power Plan never went into effect. The same day the EPA promulgated the rule, dozens of parties, including 27 states, asked for a review. I bet they did. After that court declined to enter a stay of the rule, the challenger sought review from this court. We grant a stay preventing the rule from going into effect. That was 2016. This has been going on for a while. The Court of Appeals later heard arguments on the merits en banc, but before it could issue a decision, there was a change in presidential administration. The new administration requested litigation be held in abeyance so the EPA could reconsider the Clean Power Plan. The D.C. Circuit obliged and later dismissed the petitions for review as moot. So, yeah, this is one of the issues, or, for better or worse, with the administrative state. As new administrations come into play, new administrations want different kinds of rules. So when you delegate everything to the administrative agencies, they necessarily are going to be quite impacted by the nature of who's the administration. And so the new administration said, hey, we don't really like that, so we'd like to not have this litigation go forward. And the courts, of course, are all too thrilled with that because now there's no conflict. So they're like, okay, great. You guys seem to have reached an accord. That's great. Everything's on hold. Fantastic. The EPA eventually repealed the rule in 2009, concluding the Clean Power Plan had been excess of statutory authority. It does sound that way. Specifically, the agency concluded generation shifting should not be considered as part of a best technological means. Yeah. The agency interpreted the section as limiting technological means to those systems that can be put in operation at a building, structure, facility, or installation, such as an add-on control, or an inherently lower emission processes designs. Yes, make the power plant better is what you can do, not eliminate the power plant. You can make it better, though. It then explained the Clean Power Plan, rather than setting standards based on application of equipment and practices at the level of the facility, that is, hey, what can I do actually at the facility to make this plant a better plant? What can I do to make this coal burner a better burner? How can I make it the best burner that it can possibly be? Rather than that, instead based it on a shift in generation at a grid level, not the sort of measure that has potential for application to an individual source. Yeah. The agency determined that the interpretive question raised by the Clean Power Plan, whether the shifting of emission reduction can consist of generation shifting measures, fell under the major questions doctrine. Okay, so we've got a new concept of law we're going to talk about here in a second. Under the doctrine, the EPA explained, courts expect Congress to speak clearly if it wishes to assign an agency decisions of vast economic and political significance. The we are projecting $1 trillion loss of GDP does sound like the kind of thing that might be considered vast economic and political significance. The agency concluded the Clean Power Plan was such a decision for a number of reasons. Its generation shifting scheme was projected to have billions of dollars of impact, well, apparently trillions. No section rule of the score had ever been based on generation shifting, and novel reading the statute would empower the EPA to order wholesale restructuring of any industrial sector based only on discretionary assessment of such factors as cost and feasibility. Yeah, so we've got another problem on top of this. So problem number one, we seem to not be in accordance with the statute based on the way this is being described, right? We are able to implement technological means on emission sources, possibly to different degrees, whether it's a new or existing source, and possibly on different degrees based on the nature of the pollutant. This is large part done by Congress. Congress can make choices. That's fine. And then we've got this other stuff provision. Okay, it allows us to also do some other things relating to that. Okay, great. We want to use this and other stuff provision to do lots of other stuff. No longer technological measures, mind you. It's not it's not that we want to put in place a scrubber. It's not that we want to put in place a carbon capture device. It's not that we want to change the fire mechanism or the construction or nature of the burning chamber or whatever to make it more efficient, right? Whatever that would be. It's not what we want to change the coal power plant in some way to make it a better coal power plant. We want to increase its technology because technology has changed, and we want to make it a better, more technologically sophisticated power plant. It is instead we want to shift things around from one kind of power plant to another under these kinds of authorities. So problem number one is it doesn't seem to be within the scope of the statute. Problem number two is this major questions doctrine. Congress has the authority to delegate things to the administrative agency. By some degree, this is necessary. It would be difficult for Congress to contemplate everything. I mean, they could, but it'd be a little bit tricky. So we need administrative agencies to be able to implement statutes and pass regulations and fill in gaps to some degree. So we're going to empower administrative agencies to do that. Okay. But if we're going to do that, we need to actually do it somewhat clearly, because we are delegating authority to an administrative agency to do stuff. Okay. So we have this idea called the major question doctrine, which is this idea that, okay, look, if you could read this statute to authorize this power, but it's not clear, and the amount of power you're giving it is so much power that it would, create this major problem, like $1 trillion of GDP, for example, that would fall into the question of a major problem, then we're going to try to read the interpretation of the statute against such an interpretation, right? We are going to look for interpretations that don't do that, because we assume that we're going to, more to the point, rather than assume, we're going to require that if Congress really wants to do this, they actually, do it. Clearly, we don't hide mountains in molehills, as they say. We don't hide major things in minor provisions. We're not trying to sneak one through the back door when the thing we're trying to sneak through is, massive. So we are going to require that Congress, when they delegate things that are going to have major impacts, do so clearly. And we're going to interpret statutes that otherwise seem open, to the degree they do seem open, to the degree they do seem to allow for this. We're going to interpret against it where it would have these huge, major consequences, because if Congress really wanted these huge, major consequences, it would have spoke more clearly, right? We're not going to just assume it away. So this is just, how does Congress delegate authority, basically 101. Do it with more clarity. Fine. The EP argues under the major questions doctrine, a clear statement was necessary to conclude Congress intended to delegate authority of breadth to regulate a fundamental sector of the economy. Yeah. It found none. Indeed, it concluded, given text and structure of the statute, Congress has directly spoken to this precise question and precluded the use of these measures such as generation shifting. Okay. In the same rulemaking, the agency replaced the Clean Power Plan by promulgating a different regulation known as the Affordable Clean Energy Rule. Based on this view of what it means to be permissibly make up a technological measure, the EPA determined the best system would be akin to building block 1 of Clean Power Plant, a combination of equipment upgrades and operating practices that would improve facilities' heat rates. This seems fine. This rule determined the application of measures would result only in small reductions of carbon dioxide emissions. Yes, maybe so, but it's what they're allowed to do. So fine. A number of states and private parties immediately filed a petition for review in the DC Circuit challenging the EPA's repeal of the Clean Power Plan. So whereas before a bunch of states went and said, hey, the EPA can't do that, and the EPA says, you're right, we can't do that. Now a bunch of states are like, hey, the EPA can do that, or must do that. So we're going to challenge the EPA on that, challenging the EPA's repeal of the Clean Power Plan. Other states and private entities, including petitioners here, intervened to defend both actions. So they're like, okay, we're just going to do both these things. The Court of Appeals consolidated all 12 petitions for review into one case. This is very common, right? There are different parties. There are different parties in different places, but there's a common set of law and common set of facts, common enough to adjudicate them all at once. And so in the name of judicial efficiency, great, we're going to do that. We're going to consolidate all these disparate cases into one big case, because there's enough law and fact in common to do that and save everyone time. Fantastic. This is something that can definitely happen in many different contexts, and something that does happen frequently is overstating it, but it happens. It then held the EPA's repeal of the Clean Power Plan rested critically on a mistaken reading of the Clean Air Act. Namely, generation shifting cannot be a system of emission reduction. So the Court of Appeals says, you've misread the law. Okay. To the contrary, the court concluded the statute could reasonably be read to encompass generation shifting. If it can be reasonably read that way, though, then it's up to the EPA. which again is one of the aspects of the administrative state. If it can be read either way, then the agency gets to determine this. Welcome to Chevron. Not my idea. Not my idea, but that's, if it can be read either way, then the EPA can read it this way rather than that way. The only way to overrule the EPA is to not only say it can be read that way, but must be read that way. Then you can overrule, then you can go on, then you can move past Chevron. So your reading is not only not permissible, it's forbidden. Then we can get past Chevron. Okay. As part of that analysis, the Court of Appeals concluded the major question doctrine did not apply and thus rejected the need for a clear statement of congressional intent. The Law Patrol gives $20 Australian to say happy channelversary. Well, thank you very much, the Law Patrol, for your very nice super chat to say happy channelversary. It is a glorious day here at Uncivil Law. Who knew 5 years ago when I created the channel, somewhat timidly at start, that it would now become my full-time career. This is pretty interesting stuff. Great. Okay, where were we? Having found the EPA misunderstood the scope of the authority under the Clean Air Act, the court vacated the agency's repeal and remanded the agency to further consideration. It also vacated and remanded the replacement rule for the same reason. The court's decision, handed down January the 19th of 2021, was quickly followed by another change of presidential administration, unsurprisingly, and that administration has a different view. This is Roberts, by the way. This is Roberts' majority opinion, for those who asked. Thank you. 1 month later, the EPA moved the Court of Appeals to partially stay the issuance of the mandate as it pertained to the Clean Power Plan. The agency did so to ensure the Clean Power Plan would not immediately go back into effect. The EPA believes such a result would not make sense when it is in the process of considering whether to promulgate new rules. No party opposed, the Court of Appeals stayed. Okay, so a new administration wants to have new rules, and we'd like to stay the current proceedings while we do that. The Court of Appeals is like, that sounds great to us. While you do that, fine. All right, so Westmore, NACC, and the states defending defending the Clean Power Plan all filed petitions for certiorari. We grant petitions for certiorari, so we'd like the U.S. Supreme Court to consider this after all. Okay, let's do that. The fact... Okay, yeah, and we're going to get into this issue. So, number one problem is, like, can the Supreme Court hear this issue? Because, like, apparently everyone's cool with this, and these people are not parties. They're interveners. So step one is, can we hear the case? That's a good place to start. We first consider the government's contention that no petitioner has Article 3 standing to seek our review. Yeah. This could be a problem. Although most disputes over standing concern whether a plaintiff has satisfied the requirement when filing suit, Article 3 demands actual controversy persist through all stages of litigation. Yes, you must have standing at all times. If you lose standing for any reason, game over. The requirements of standing must be met by persons seeking appellate review, just as it must be met by persons appearing in courts in the first instance. Yes, you must have standing at all stages. Perpetually. In considering a litigant standing to appeal, the question is whether it's experienced injury fairly traceable to the judgment below. If so, and a favorable ruling from the appellate court would redress that injury, the appellate has a cognizable Article 3 stake. Okay, here it's apparent that at least one group of petitioners, the state petitioners, are injured by the Court of Appeals judgment. Okay, that judgment vacated the ACA rule and its embedded repeal of the Clean Power Plan, and accordingly purports to bring the Clean Power Plan back into legal effect. Does it, though? I thought we stayed that. Okay. Thus, to the extent the Clean Power Plan harms the states, the D.C. Circuit judgment inflicts the same injury. And there can be little question the rule does injure the states, since they're the object of the requirements that they more stringently regulate. If the plan is in effect, then yes, but if it stayed, then I'm not so sure. The government contends that the agency and judicial actions subsequent to the court's entry of judgment have eliminated possibility of injury. This is a reasonable argument. First, after the decision, the EPA informed the Court of Appeals it does not intend to enforce the Clean Power Plan because it's decided to promulgate a new rule. Second, on EPA's request, the lower court stayed that part of the judgment that vacated the repeal pending new rulemaking. These circumstances have mooted the rule. That seems like a reasonable argument. That Freudian slip, however, reveals a basic flaw in the government's argument. It's a doctrine of mootness, not standing, that addresses whether an intervening circumstance has deprived the plaintiff of a personal stake in the outcome of lawsuit. Okay, the distinction matters because the government, not petitioners, bears the burden to establish that one's live case has become moot. Okay, that burden is heavy, whereas here, the only conceivable basis for finding a mootness in the case is respondent's voluntary conduct. So we're going to say that it didn't become moot because you yourself are the ones rendering it moot and trying to basically escape judgment. There is case law that stands for this proposition, by the way. It's like if it's merely voluntarily cessation, then that does not deprive the courts of jurisdiction, because if you could resume it at any time, then, you know, it would just lead to this endless chase, right? It's like, okay, we have the plan in place. Okay, I'm going to sue. Oh, we've decided not to for the moment. Okay, it's moot. Case dismissed. Oh, we've decided to again. You know, case. Oh, no, we've decided not to. Okay, it's dismissed, right? So it would allow you to play games, and we're not going to let you do that, right? We're not going to let you yourself voluntarily decide to, like, just stop for the purpose of creating mootness, because that would lead to an abuse of the system. That seems perfectly logical. So the government's mootness arguments boils down to representation. The EPA has no intention of enforcing the Clean Power Plan. But voluntary cessation does not moot the case unless it's absolutely clear the alleged wrongful behavior could not be reasonably expected to occur. It's not moot unless it is. If you could bring it back, we're not going to let you play games. Here, the government nowhere suggests if this litigation is resolved in its favor, it will not reimpose emission limits predicated on generation shifting. Indeed, it vigorously defends the legality of such an approach. We do not dismiss the case as moot in such circumstances. Okay, this is an exception to mootness doctrine. It's logical. There's room to disagree with it, but it's logical from the case law. So fine. Let's turn to the merits. In devising emission limits for power plants, the EPA first determines the best system of emission reduction that, taking into account cost, health, and other factors, finds has been adequately demonstrated. Best technological means that are economically viable, I guess is the right way to phrase this. The agency then quantifies the degree of emissions limitations achievable if the best system were applied. The rule, therefore, is central determination the EPA must make in formulating its guidelines. Best technological measure that is economically feasible. Okay. The issue here is whether restructuring the overall mix of electricity generation to transition from 38% coal to 27% coal can be thought of the best technological measure. No. It's a fundamental canon of statutory construction. The words of a statute must be read in their context and within view of their place in an overall scheme. Yes, words have the meaning they have based on the context of the statute as a whole. One of the things that you want to do when interpreting a statute, or constitutional provision for that matter, or anything else, is you interpret words also by the company of the words they keep. Because when you're writing a statute, one is assuming that Congress, being a smart Congress, and I know we're assuming a lot, but press on, Congress being a smart Congress intends the entire statute to be read within its own context. To the degree that you have multiple statutes that are in the same context, we assume Congress, being a smart Congress, and I know we're assuming a lot, but let's press on, assumes all those statutes to be read in context with each other. So to the degree that there is any sort of uncertainty or conflict, we are going to assume that if there's a conflict in a statute, within its own terms, within other parts of the statute, as between statutes, we're going to assume the conflict out of existence if we can. One of the things is this avoidance idea. We're going to avoid the conflict. We're going to avoid the internal conflict of the statute. Congress is a smart Congress. I know. Press on. Congress is a smart Congress, and we're going to assume that it's us that are ones that are dumb. And so if we perceive a conflict, it must be us who don't get it. So we're going to assume the conflict out of existence, if it's possible, so that we give full faith and credit to everything Congress wrote, because surely they didn't mean that, because they wouldn't have written something that's in conflict with itself. All right, it's only if we can't avoid it that we're then going to move on to other parts of the analysis. So same idea with interpreting a word of a statute. We're going to interpret it along with the company it keeps, because, probably Congress meant the entire statute or statutes to be understood together. And so if we're trying to interpret what a word means, let's interpret it in context. Seems like a good idea. Great, let's do that. When a statute at issue is one that confers authority upon an administrative agency, the inquiry must be shaped, at least in some nature, by the nature of the question presented, whether Congress in fact meant to confer power. That's what did Congress write? What did Congress actually do in terms of conferring power? Yes, that's helpful. In the ordinary case, this context has no great effect on appropriate analysis. Yes, normally Congress is a smart Congress, and we don't have to move to context because we are able to get it because we're able to understand. Nonetheless, our precedent teaches, therefore, there are extraordinary cases that call for a different approach. Those cases in which history and breadth of the authority the agency has asserted, and economic and political significance provide a reason to hesitate before concluding Congress meant to confer such authority. This is the major questions doctrine just wrapped up all into one, right? It's like, yeah, if our reading of this were correct, Congress would be delegating boatloads of power. So we're going to assume that maybe they didn't mean that unless they said it with clarity. Because if Congress is going to upset the economy to the tune of $1 trillion of GDP, that is something Congress might very well have the power to do, but we're going to read it with a little bit of judicial care. Fantastic. Fantastic. All right. Such cases have arisen from all corners of the administrative state. In a different case, for example, with the FDA, claim the authority over drugs and devices, include the power to regulate and even ban tobacco. We rejected that expansive construction of the statute, concluding Congress could not have intended to delegate such sweeping and consequential authority in such a cryptic fashion. We conclude the Center for Disease Control could not, under its authority to adopt measures necessary to prevent the spread of disease, institute a nationwide eviction moratorium to the COVID-19 pandemic. Again, for me, the major question doctrine is not we don't really need it. It's just for the COVID-19 thing, it wasn't even in the statutory text. It didn't even make any sense in this text. But if it did make sense, major question doctrine. So we've got multiple different reasons to reject it. We then found the statute's language wafer-thin reed on which to rest such a measure, given the sheer scope of the claimed authority, its unprecedented nature, and the fact Congress had failed to extend the moratorium after previously done so. Our decision in a different case addressed another question regarding EPA's authority, namely, whether the EPA could construe the term air pollutant in a specific provision of the Clean Air Act to cover greenhouse gases. Despite the textual plausibility, we know the agency's interpretation would give it permitting authority over millions of small sources, such as hotels and office buildings that had never been subject to such requirements. We declined to uphold the EPA's claim of this unheralded regulatory power over a significant portion of the economy. So again, what is a pollutant gas? Well, maybe carbon dioxide is a pollutant gas, but if it is, it would lead to this stuff, and that's a lot of stuff. So we're going to assume that Congress didn't mean to imbue you with godlike power. We're going to interpret against the godlike power? That makes sense. In a different case, we confront the Attorney General's assertion he could rescind the license of any physician who prescribed a controlled substance for assisted suicide, even in such a state where it was legal. The Attorney General argued that this came to him within his statutory power to revoke licenses when he found them inconsistent with the public interest. We consider the idea that Congress gave him such broad and unusual authority through an implicit designation not sustainable. It's too much. It's too much. We're not going to let you change the world on such broad language. We're going to require Congress to be a little bit more specific. Similar considerations informed recent decisions invalidating the OSHA mandate. Yeah. We found it telling that OSHA, in its half-century of existence, had never relied on authority to regulate occupational hazards to impose such a remarkable measure. Yeah, where are the hard hats and where are the PPE? But get the vaccine. All these regulatory assertions have colorable textual basis. So there is some text to do this. So let's give credit where credit is due, right? We are moving outside the idea of textualism, or at least challenging it, right? So we're challenging the idea of textualism because the text could feasibly be read to allow for this. So we have to move beyond a pure textualism. And so now we have to be, if we're going to do that, we have to do that in some sort of consistent principle, because textualism is great. I like the textualism. Textualism is my friend. This is why I like Gorsuch's decision in Bostock so much, because it's a textualist argument, and it's great. And I think it's fantastic. So is textualism the end of the analysis? Do we merely look strictly at what Congress wrote? Well, that would be one way to go, to be sure. But we can and perhaps should have things that are competing with that. And those things, by the way, themselves are rooted in constitutional principles. We're not getting them out of nowhere. Textualism is coming from a constitutional principle. Congress is the one that passes laws. They're the ones that write words. The president signs the bill into law, the words, right? Congress has the power to use words to create law. We are honoring the words that Congress chose from its power to create laws. This is obviously rooted in constitutional principles. So if we're going to challenge that in some way, we want to challenge that using another constitutional principle, right? Because we need constitutional principles to challenge constitutional principles. It's the only way to work. So what constitutional principle can we call upon? Okay, we're going to call on this idea, this major question doctrine. Congress has the power to delegate to the administrative agency. But it has to actually do that. It has to actually do that through the words it chose. Congress can do it if it uses words. Fine. We're going to assume that generic language is meant as gap fillers, which makes perfect logical sense. The and other stuff provision is gap fillers. And we're going to assume that Congress didn't mean to delegate godlike power through an and other stuff provision, or these other sort of texts that are vague. Congress has power to use words to create law. These powers you're creating, arguably, are incredibly massive, and the language that you have to support it is very thin. You can read it as existing, but it's thin. So we're going to assume that Congress didn't delegate these broad, overarching, massive powers through vague, obscure, broad language. That wasn't what Congress had in mind. This is not what those words mean. It's one way to read the words, but if we read the words that way, we'd be concluding Congress intended to do this, and no, it doesn't seem in keeping with the language that we have. So this is the idea of major questions doctrine. It's something you could obviously attack, and I'm sure the minority opinion will spend no time wasted on attacking the concept, but there is a constitutional basis to base it. Congress actually has to do the thing, and we're going to want them to actually do the thing. So there is a constitutional basis for the principle. There's reasons to attack the principle, but there's a constitutional basis for it. Extraordinary grants of regulatory authority are rarely accomplished through modest words, vague terms, or subtle devices. We're going to want something a little bit clearer. Nor does Congress typically use oblique or elliptical language. That would be the ... right? and other stuff. That's elliptical language, right? It's where we give a series of lists and then we follow it by ellipse, right? We follow it by ellipse. Oh, you can do this, 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 dot, dot, dot. Well, sometimes the dot, dot, dot is expressed in language, and we just call it elliptical because it's an ellipse. It's just the and other stuff. To allow the agency to make radical or fundamental change to a statutory scheme. Okay. Agencies only have those powers given to them by Congress. This much is undisputed. This much is clear. And enabling legislation generally is not an open book on which the agency may add pages and change the plot line. Yeah. We presume Congress intends to make major policy decisions itself, not leave those decisions to the agencies. Yeah. This is Congress can do it, but they actually have to do it. And we're going to assume they didn't do it when the consequences are this massive. Thus, in certain extraordinary cases, both separation of power principles and practical understanding of legislative intent makes us reluctant to read in ambiguous statutory text. Separation of powers because Congress has the power to delegate, but if they didn't, the administrative agency is trying to claim more power than Congress gave them. Only Congress can create law. The administrative agency enforces law. They don't create law. So if the administrative agency is trying to create law, no. A practical understanding of what they meant probably didn't mean that. Makes us reluctant to read into an ambiguous statutory text these broad delegations. To convince us otherwise, something more than merely plausible textual basis for agency action isn't necessary. The agency instead must point to clear congressional authorization for power it claims. This is perfectly logical. This is perfectly logical. Congress can delegate it. It's just a question of did it delegate? And we're going to assume when you have this elliptical language, the dot, dot, dot language, the and other stuff language, the gap keeping language, we're going to assume it's meant to fill gaps, not construct monuments. You know, we need something a little bit more specific. Dissent criticizes us for announcing the arrival of the major questions doctrine. This is not the arrival of it. It definitely existed before this moment, I assure you. And argues that each method of decision just cited simply follows our ordinary method of normal statutory interpretation. I mean, fair enough. I mean, you don't have to call this the major questions doctrine. So maybe there's a mistake there for calling it the major questions doctrine, right? You don't need this label. You could just say, well, the language keeps the company of the things it keeps, and it's not like that, so it's not part of the grant. Like, you don't need to necessarily create this concept called the major questions doctrine to do what you're doing. So maybe it's a mistake to create this label because we could do it through other labels. And so maybe there's a mistake there. That's fine. We could get there through other mechanisms though. So in some degree, maybe it doesn't matter. But if we're looking to the future and we're wondering about the future, maybe there's a problem. Okay. But what the dissent calls the key case in this area, the court could not have been clearer that in extraordinary cases, there may be reasons to hesitate before accepting a reading of the statute that would, under more ordinary circumstances, be upheld. Or as we put it more recently, we typically grant assertions of extravagant statutory power over the national economy with skepticism. Yeah, there's a lot of this idea in the law. If you don't like the label major questions doctrine, then fine, but this idea is certainly there. The dissent attempts to fit the analysis in these cases within routine interpretation, which you might very well be able to do, but the bottom line, a requirement of clear congressional authorization, confirms the approach under major question doctrine is distinct. I'm not sure if it is distinct. Maybe it's not distinct. Maybe it also doesn't matter. As for the major questions doctrine label, it took hold because it refers to an identifiable body of law that's developed over a series of significant cases, all addressing a particular and recurring problem. Scholars and jurists have recognized the common threads between these decisions, so have we. Okay, fine. So we have a bunch of cases that speaks to a principle. We can use ordinary, normal tools to get there, but now we have a group of these cases. And so now we're going to say that they speak to, and we're going to give a label to this group of cases. What shall we call it? We can call it something else, but we've decided to call it the major questions doctrine. Okay, so we've given a label to the thing. I suppose we didn't have to some degree, but We could have just not labeled it and done the exact same thing, but what difference would it have made to some degree? Unless we're worried about the future, and we're worried about where this doctrine might go in the future. And giving it a name perhaps allows it to be misused, but at least at the moment, it's a little bit academic. Under our precedents, this is a major question case, whether we call it that or not. In arguing that Section 111 empowers it to substantially restructure the American market, the EPA claimed to discover a long extant statute of unheralded power representing transformative expansion as regulatory authority. Yeah, if you're finding something Congress wrote 50 years ago, you'd be like, ooh, magic. No one up till now discovered the magic. It's like, It located that power in vague language of ancillary provision of the Act, one that was designed to function as a gap filler and rarely been used. It was meant to fill in gaps, not to construct cathedrals. It was meant to patch the brickwork, not become the brickwork. As the agency discovery allowed it to adopt a regulatory program, Congress itself has repeatedly declined to enact. So Congress has tried to do this itself and not been able to do it, which suggests that is suggestive, although not determinative, is suggestive that the acts didn't already allow for it, because Congress sometimes does repetitive stuff. But Congress's inability to do it is at least a suggestion that it is not somewhere else. Prior to 2015, the EPA has always set emission limits under 111 based on applications of measures that would reduce pollution by causing the regulated source to operate more cleanly. It has never devised a cap by looking to a system that would reduce pollution simply by shifting it from a dirtier to cleaner sources. And as Justice Frankfurter has noted, just as established practice may shed light on the extent of power conveyed by general statutory language, so want of assertion of power by those who presumably would be alert to exercise it is equally significant in determining whether power was conferred. So practice is one way of interpreting a statute. It's also one way of interpreting a contract, incidentally. The practice of the parties, the behavior of the parties, is relevant in interpreting contractual language. So, like, if you have vague or unclear language in a contract, then the behavior of the parties is going to go a long way to informing what that language means. By the way, incidentally, even if you have directly clear language in a contract, the behavior of the parties will inform it because it might constitute, for example, waiver. So if you have a contract provision that's blatantly in conflict with ongoing repeated party action, then, well, maybe that provision has been waived or modified or something, because your behavior is going to be relevant in interpreting the contract. Similar concepts at work here. The government quibbles with this description of the history, pointing to one rule it said relied upon cap-and-trade mechanism to reduce emissions. The legality of that choice was controversial at the time and never addressed by the court. Even assuming the rule was valid, though, it still does not help the government. In that regulation, EPA set actual emission cap, the limits on emissions that sources would be required to meet, based on level of mercury emissions reductions that would be achievable through technologies that could be installed, namely a wet scrubber. Well, it sounds like a technological means to me. In other words, the EPA set the cap based on applications of particular controls, and regulated sources could have complied by installing them. By contrast in design, there's no control a coal company operator can deploy to attain the emission limits established by the Clean Power Plan. This consistent understanding of systems of emission reduction tracked in seemingly universal view is stated by the EPA in its Section 111 rulemaking. Congress intended a technological-based approach to regulating that section. A technological-based standard recalls one that focuses on improving emissions. EPA commonly referred to that as level of control required as best demonstrable technology standard and constantly applied it as such. Indeed, the EPA nodded this history in the Clean Power Plan itself, describing the sort of systems of emission reduction it has always selected: efficiency improvements, fuel switching, add-on controls, as more traditional air pollution measures. The agency noted it considered such measures as potential systems of emission reduction for carbon dioxide, including a measure ultimately adopted as a component of the best technological means, namely heat rate improvement. But as agency noted, in order to control CO2 from affected plants at levels necessary to mitigate damages by climate change, it could not base the emission limits on measures that improve efficiency, which is what it could do. The quality of emissions reductions resulting from applications of these measures would have been too small. Thank you very much, Yvonne, for your nice happy birthday message. That's very kind of you. Thank you. The EPA adopted what it called a broader, forward-thinking approach to the design of Section 111 regulations, rather than focus on improvement of performance for individual sources. It would improve the overall power systems by lowering carbon intensity of power generation, and would do so by forcing a shift from one type of energy source to another. That seems like a lot. In the words of the then EPA administrator, the rule was not about pollution control, which is exactly what the EPA is supposed to do, the pollution control, so much as it was an investment opportunity for states, especially investment in renewables and clean energy. It sounds like it's outside the EPA's purview. Oversight, based on an oversight hearing, where they apparently said this. The view of EPA's authority was not only unprecedented, it also affected a fundamental revision of the statute, changing it from one scheme of regulation to an entirely different kind. Under the agency's prior view of Section 1111, its role was limited to ensuring the efficient pollution performance of each individually regulated source. Under newly discovered authority, however, the EPA can demand a much greater reduction in emissions based on very different kinds of policy judgment. And we best if coal made up a much smaller share of the national electricity. In this view of the EPA authority, it could go further, perhaps forcing coal plants to shift away virtually all their generation, to cease making power altogether. That would seem to be a logical consequence. Why can't you? And that is like more than, we gave you. The government attempts to downplay the magnitude of this unprecedented power over the American industry. The amount of generation shifting ordered, it argues, must be adequately demonstrated, and best in light of the statute, in view of cost, non-air quality, health, and environmental impact and energy requirements. EPA therefore must limit the magnitude of generation shift it demands to a limit that will not be exorbitantly costly or threaten reliability of the grid. But this argument does not so much limit the breadth of the government's claimed authority as reveal it. On Section 111, on their view, Congress implicitly tasked it, and it alone, with balancing many vital considerations of national policy, implicating deciding how Americans will get their energy. EPA decides, for instance, how much of a switch from coal to gas is practically feasible by 2020, 2025, and 2030 before the grid collapse, and how high energy prices can go before the result becomes unreasonably exorbitant. Thank you very much, XZZ, for NOK 100 is appreciated, and well, it is well appreciated. Thank you. There's little reason to think Congress assigns such decisions to the agency. For one thing, as the EPA itself admitted when requesting special funding, understanding and projecting system-wide trends in areas such as electricity transmission, distribution, and storage requires technological policy and expertise not traditionally needed by the EPA. When an agency has no comparative experience in making certain policy judgments, Congress presumably would not have tasked it with that. We also find it highly unlikely Congress would have lead to agency discretion on how much coal-based generation there should be over the much coming decades. The basic and consequential trade-offs involved in such a choice are ones Congress would likely have intended for itself. The dissent contends there's nothing surprising about the EPA dictating the optimal mix of sources nationwide, since that sort of mandate would reduce air pollution from power plants. But that does not follow. Forbidding evictions may slow the spread of disease, but the CDC's ordering such a measure certainly raises an eyebrow. We would not expect the Department of Homeland Security to make trade or foreign policy, even though doing so could decrease illegal immigration. And no one considering generation shifting tool in OSHA's toolbox even though reducing generation at coal plants would reduce workplace illnesses from coal dust. The dissent also cites our decision in American Electric Power versus Connecticut. The question there was whether Congress wanted district court judges to decide under unwritten federal nuisance law whether and how to regulate carbon dioxide emissions from power plants. We answered no, given the existence of Section 111. We said nothing about the way in which Congress intended EPA to exercise its power under that provision. And it's doubtful we had in mind that it would claim authority to require a large shift from coal to natural gas. Good times. What about Flint? JC Adult says 101. Happy 5 years and 100K. Thank you very much. It is extremely appreciated. Thank you. I appreciate your super chats. I appreciate all of you guys. I appreciate the 297 of you who are here to listen to a fairly in-depth legal discussion about the EPA. Administrative state, administrative power, delegation of power, major question doctrine, interpretation doctrines, and so forth and so on. This is pretty hardcore law geek right here, right now, and I appreciate there are 300 of you to be here with me as we're doing this. It's very, very validating. Thank you. Thank you all. Finally, we can ignore the regulatory writ EPA newly uncovered conveniently enabled it to enact a program that, having long posed the dangers posed by the greenhouse gas emissions, had become well known. Congress considered and rejected multiple times. At the bottom, the Clean Power Plan essentially adopted a cap-and-trade scheme, or set state cap-and-trade schemes for carbon. Congress, however, has consistently rejected proposals to amend the Clean Air Act to create such a program, which is suggestive that it's not part of the law already. It's not determinative, but it is suggestive. Will I go over the dissent? At least in part, yes, I will go over the dissent, because I'm interested in what they had to say. Catamo says, it's honestly great when you geek out. Thank you. Steven says, I cherish your lessons on law, even as in-depth as it is. I know. This is great, though, because it's reaching, this case is reaching for some fundamental principles, right? Proper ways of statutory interpretation, delegation of powers, proper understanding of administrative role, proper understanding of administrative regulations, separation of powers, major question doctrine, and so forth and so on. So we get to geek out pretty hard because this case is bringing to mind and showing us like 6 or 7 major principles all at once. And we get to geek out on those principles all at the same time and show how they interact. This is a lot of fun. This kicks ass. Given these circumstances, our precedent counsels skepticism towards the EPA claim that empowers it to devise carbon emission caps based on a generation shifting approach. To overcome that skepticism, the government must, under the major questions doctrine, point to clear congressional authorization. All the government can offer, however, is an agency's authority to establish emissions caps at levels reflecting the application of best systems of emissions reduction adequately demonstrated. Sure. Ooh, cool. Apparently my editor has already edited my video. Okay, cool. I hired an editor, so we'll see how they did. Let's see, where were we? As a matter of definitional possibilities, generation shifting can be described as a system of aggregation or assemblage of objects united by some form of regular interaction. But of course, almost anything could constitute such a system. Short of all context, the word is an empty vessel. Such a vague statutory grant is not close to the sort of clear authorities recognized by our precedent. Very, very cool. Okay, cool. The government, echoed by other respondents, looks to other provisions of the Clean Air Act for support. It points out that the Act elsewhere uses the word system or similar words to describe cap-and-trade schemes or other sector-wide mechanisms for reducing pollution. The acid rain program set on Title IV of the Act establishes a cap-and-trade scheme for reducing sulfur dioxide emissions, which the statute refers to as emission allocation and transfer system. And Section 110 of the other program specifies that marketable permits and auctions of emissions rights qualify as control measures, means, or schemes. So when Congress does want to speak clearly about this, they do, as they apparently did when it came to sulfur dioxide. This language seems a lot clearer to me. If the word system or similar words like technique or means can encompass cap and trade, why not in Section 111? Well, because in those sections they specified it with a lot more specificity. But just because cap and trade system can be used to reduce emissions does not mean it's the kind of system referred to in Section 111. Yeah, I mean, duh. In the other section, we specified the system with quite a lot of clarity of what that system is. Here, in this, you don't have that kind of language. So the example is completely inappropriate. Fred says, I hear YouTube is pushing video shorts for channel growth. Yes, that is also what I've heard. It's not for nothing that recently you've seen a massive increase in my shorts production. I don't really do shorts, but as you have noted, I'm sure recently, like in the last couple of days, I produced quite a few shorts. There's a reason. Yes, I'm well aware that it appears to be the YouTube algorithm likes the shorts, and that's fine by me because they're a lot easier to produce. It's just me talking for 60 seconds and uploading it. That's easy enough. So like, okay, you want me to make a video that's 60 seconds long? Okay, I can do that. I can cram everything into 60 seconds. That's fine. So yes, lots more shorts in your immediate future. Forcing that crap is dumb. It may well be dumb, but if YouTube is going to help increase my subscriptions by me doing shorts, guess what we're doing, friends? We're doing shorts. If the YouTube algorithm likes the shorts, and it will increase my subscription count and increase the reach of this channel and help the channel grow, I am more than happy to do a couple shorts. We'll do a couple shorts during the day. We'll still have our regular long form stuff. Everyone's happy. Right? Everyone's happy. First, unlike Section 111, the acid rain and program contemplate trading systems as a mean with complying with an already established limit. In Section 111, by contrast, it's the EPA's job to come up with the cap itself. The numerical limit on emission states must apply for each source. Will you do the shorts wearing shorts? I'm wearing shorts right now. Use the shorts as commercials for an in-depth video? Yeah, basically that's what we're doing. Yeah. Put your videos at 2x speed, have people slow it down. No, it's not feasible. The mechanisms within shorts to do that are not feasible. It's better just to do it at 1x. We'll press on. But I appreciate the idea of what you're trying to do. If what you're trying to do, by the way, is invoke the idea the Spiffing Brit had, like yesterday with the whole 2x thing, I'm not sure that is replicatable. And certainly I don't think it's replicatable within the shorts. So all due respect to Spiffing Brit and all, but I don't know that, yeah, that's workable. But I appreciate his ideas. Okay, where was I? Second, Congress added the above authorizations for use of the emission trading program in 1990. All my shorts should just be advertisements for actual videos? Yeah, basically that's what they're going to wind up being. That's fine. Yeah. So, like, that makes it easier, right? In some sense, like, if I have a planned release in the afternoon, I can do a short in the morning about what you're going to see this afternoon. Makes an advertisement for it. That works. Yeah, that works. At the time, cap and trade was a novel and highly touted concept. The acid rain program was the nation's first ever emissions trading program, and Congress went out of its way to amend the statute to make absolutely clear the measure, means, and techniques states could use to meet the included cap and trade. Yet not a peep was heard from Congress about the possibility a trading regime could be installed under a different section. Finally, The government notes that other parts of the Clean Air Act, past and present, have explicitly limited the... so after this is over, I'll probably just release a short about this and be like, just release a short and be like, if you want to see more, check out the full video on my channel. So, yeah, I'll just do that too. That's fine. For instance, a separate section of the statute empowers the EPA to require a degree of reduction achievable through retrofit application of best systems of continuous emissions reduction. The comparative unadorned use of the phrase best systems of emission reduction, the government urges, suggested a clear congressional choice not to limit the measures they may constitute to the best measures. These arguments, however, concern an interpretive question that's not an issue. We have no occasion to decide whether the statutory phrase system of emissions reductions refers exclusively to measures that improve pollution performance of individual sources, such as those of all other actions that are ineligible to qualify as a best technological measure. To be sure, it's pertinent to our analysis that the EPA has acted consistent with such limitations for the first 4 decades of the statutes, but the only interpretive question before us, and the only one we answer, is more narrow. Whether the best system identified by the EPA in the Clean Power Plan was within the authority. For these reasons, we say no. Do a shorter short? I could do a 15-second short. I've never done a 15-second short. That can be interesting. Does EPA have the EPA has tried to reduce emission limits coming from coal power plants. Do they have the authority to do so? Well, for full analysis, check out my video at Uncivil Law. I could do something like that, maybe. Yeah. All right, so let's read some other opinions. Justice Gorsuch concurs. Skim, skim, skim. Skim, skim, skim. Skim, skim, skim. Yeah, I mean, I remember learning about major questions doctrine in law school, and that was 15 years ago. So it's not a novel thing, that's for sure. The court has applied the major questions doctrine for the same reason applied to other similar clear statement rules. Blah, blah, blah. Blah, blah, blah. Yeah, this all makes logical sense. It's one of the most major sectors in the United States. The question becomes, what qualifies as clear congressional statement? Yeah. So we look to some things to help establish that. Past behavior, past interpretations. Skepticism when there is a mismatch between the agency's expertise and what it's trying to do. All right, let's see what we got in terms of dissent. Today, the court strips the EPA of the power Congress gave it to respond to the most pressing environmental challenge of our time. Okay. Climate change causes and dangers are no longer subject to serious doubt. Modern science is unequivocal that human influence, in particular, has emission of greenhouse gases like carbon dioxide, has warmed the atmosphere, ocean, and land. The Earth is now warmer than at any time in the history of modern civilization, with the 6 warmest years on record all occurring in the last decade. The rise in temperatures brings with it an increase in heat-related deaths, coastal inundation and erosion, more frequent and intense hurricanes, floods, and other extreme weather events, drought, and destruction of ecosystems, and potentially significant disruption of food production. If the current rate of emissions continues, children born this year could live to see parts of the eastern seaboard swallowed by the ocean. Rising waters, scorching heat, and other severe weather conditions could force mass migrations, events, political crisis, civil unrest, and even state failure. And by the end of this century, climate change could be the cause of 4.6 million excess yearly deaths. Congress charged the EPA with addressing these potentially catastrophic harms, including through regulation of fossil-fueled power plants. Section 111 of the Clean Air Act directs the EPA to regulate stationary sources of any substance that causes or contributes significantly to air pollution and may reasonably be anticipated to endanger the public health or welfare. Carbon dioxide and other greenhouse gases fit this description. The EPA thus serves as nation's primary regulator of greenhouse gas emissions. Among most significant of the entities it regulates are fossil fuel-fired, namely coal and natural gas power plants. Today, these electricity plants are responsible for about 1/4 of the greenhouse gas emissions. Curbing that output is a necessary part of any effective approach for addressing climate change. This sounds a lot like a policy argument rather than a legal argument, by the way, so far. To carry out the Section 111 responsibilities, the EPA issued the Clean Power Plan. The premise of the plan, which no one really disputes, was that operational improvements at the individual plant level would either lead to only small reductions or would cost far more than readily regulatory alternatives. The alternative, which fossil fuel power plants were already used to reduce their carbon dioxide emissions in a cost-efficient manner, is called generation shifting. No. As the court explains, that term refers to ways to shifting electrical generation from higher emitting sources to lower emitting ones, more specifically from coal-fired to natural gas, and from both to renewable sources. A power company might divert its own resources to a cleaner source, or might participate in a cap-and-trade system with other companies to achieve these emissions. But Congress didn't write any of that. This court has obstructed the EPA's effort from the beginning. Right after the Obama administration issued the Clean Power Plan, the court stated its implementation. That action was unprecedented. Never before had courts stated regulation then under review in lower courts. Okay. The effect on the court's order followed by Trump administration's repeal of the rule was the Clean Power Plan never went into effect. The ensuing years, though, proved the plan's moderation. Market forces alone caused the power industry to meet the plan's targets through exactly the same kind of generation shifting. So market forces did it anyway. So okay. So by the time yet another president took office, the plan became, as a practical matter, obsolete. For that reason, the Biden administration announced that instead of putting the plan in effect, it would commence a new rulemaking. If this court determined to pronounce on the legality of the old rule anyway, well, for the reasons that they had stated, it was not a complete abandonment. They had only mooted it. They didn't. The court may be right that doing so does not violate Article 3 mootness, but the court's docket is discretionary, and because no one is subject to the Clean Power Plan terms, there's no reason to reach out to decide this case. I mean, arguable. The court issues what's really an advisory opinion. The new rule will be subject anyway to immediate pre-enforcement judicial review, but the court could not wait even to see what the new rule to constrain EPA efforts to address climate change. Well, because there's certain things they can't do. And so, well, telling them those things will help them write a regulation that's in conformity with the law, so there's that. The limits now places on the EPA authority fly in the face of the statute. It does. The majority says it's simply not plausible that Congress enabled EPA to regulate power plants emissions through generation shifting. But that's just what Congress did when it broadly authorized. See, that's the problem. Broadly authorized. That's the problem. In Section 101, select the best system of emission reductions for power plants. Yes, for the power plants. Not to get rid of power plants, but to make the power plants better. The best system, full stop, no ifs, ands, and buts of any kind relevant here. The parties do not dispute the generation system is the best system. Not with respect to the power plants, it's not. It might be the best system with respect to reducing the pollutants, but that's not what the law calls for. And no other provision in the Clean Air Act suggests that Congress meant to foreclose the EPA from selecting that system. To the contrary, the plan's regulatory approach fits hands in glove with the rest of the statute. The majority decision rests on one claim alone. Generation shifting is just too new and too big a deal for Congress to have authorized it in the general terms. But that's wrong. A key reason Congress makes broad delegations is so an agency can respond appropriately and commensurately to big problems. Congress knows what it doesn't and can't know within drafts of statute, and Congress therefore gives expert agencies the power to address even significant ones when they arise. That is what Congress did. The majority today overrides that legislative choice. In doing so, it deprives the EPA of power needed and power granted to curb emission. Not the way the majority describes it, no. That doesn't make sense. Not the way the statute is written. So, Did West Virginia win? Yes, West Virginia won. Yeah. It's just, I think it's not particularly surprising the more progressive wing of the court doesn't have a problem with the administrative agency having all kinds of power, because the more progressive wing of the court seems to love the administrative agencies and them having lots and lots of power. So, I mean, when, so, yeah, I don't really have much more to say about that right now. I want to thank people who helped donate to the chat, by the way. It helps a lot with the channel in terms of its growth. $5 from Mary. And me too. I'm late. Glad to see you. I'm glad to see you too, Mary. Thank you for being here. Yeah, it helps a lot with the channel and channel's growth. It helps make this possible, and helps, for example, me fund an editor or someone help with the channel and stuff like that. So all that good stuff. So we'll see about all that. So yeah. Anyways, that's all for now. I'm going to sign off for now. I'm going to probably do some bar study. I might do it online or not. And then tonight, I suppose, we will have revealing of my play button, which is currently somewhere out on a UPS truck. Yeah, I don't know how. Okay, I'll respond back. How do I respond back? Can I respond back to you? Reply. Okay. All right. Sorry, I wanted to complete a thought. Yeah, I'm going to sign off for now. And thank you very much for everyone for your chats and stuff. All right, I'm going to sign off for now. I'll talk to you guys later. Bye.